Exercise 22. Legal. The Chief Executive Officer of Express newspapers gave the entire background in his affidavit by way of evidence and exhibited various documents. 1. He identified the signatures of Mr. Ramnath Goenka on various letters. The entire case of Express newspapers, as per the plaint, has been reiterated by this witness. According to him, subletting took place on 1st February 1960, but the supplemental lease deed was only executed on 17th November 1964 for the purposes of collecting premium and not for the purpose of granting any permission. As per him, a supplemental agreement is not a condition precedent or an event anterior to the actual letting out, since the only reason was that the area west of the sewer line could not be constructed upon after the deviation of the said line. Construction was not prohibited. Express newspapers could not be blamed. Permissions for changing of the use of area was sought for Express newspapers had agreed to reimburse the cost of reconstruction of the new drainage outside its plot. In fact, the pursuant to a letter where permission was sought for building 5-story building, the Ministry of Workers and Housing inspected the premises. This letter, written by the Deputy Secretary, was conveyed to the L&Do. All requisite approvals were obtained. It was the DDA which sanctioned the FAR of 360 on 4th November 1978. He also stated that the L&Do was fully informed from 1977 onwards of all the approvals which were being received by its relating to diversion of sewer line, change of user west of the sewer line, and the construction, sanction of building plans. He further averred that no misrepresentation was committed to obtain the additional area. Moreover, there was no intention to let out the portion for commercial purposes. However, surprisingly, the January 1980 an attempt was made re-enter the building, despite Express newspapers having made efforts to keep the L&Do informed at every stage. Allegations were made by the said witness against the Lieutenant Governor at that time. Allegation was a demand of rupees 35 lakhs for converting it into a commercial building was also raised on the basis of report of a 3-member committee in this case. As per the committee, the basement area, which is to be used for the press purposes is already permitted for commercial use as per the master plan. The committee report further noted that there is unauthorized construction to the extent of 18,000 square feet in the basement area. Therefore, the unauthorized construction for a space of 70,000 square feet leads to annual rental income of more than rupees 60 lakhs here. Express newspapers then filed a writ petition under Article 32 of the Constitution of India on 1st April 1980, and on the 7th April 1980 a stay was granted, which was confirmed on 9th May 1980. Various issues were raised before the Supreme Court, which led to the quashing of the show cause notice here. Thereafter, the notice dated 1st August 1986 was received, raising various contentions on behalf of the L and do here. A show cause notice was issued on 1st August 1986, wherein it was threatened that proceedings for re-entry would be taken. All the correspondence thereafter is also summarized by the witness. Finally, the witness exhibited the news report in the TOI re-entry notice and the recovery notice. According to the witness, the impugned notice were misconceived as there was no misuse and permission was granted for additional construction. Subletting was not prohibited and commercial use was also not prohibited. The use of the basement for newspaper purposes were also permitted there. Reliance is placed upon the decision of Supreme Court and various other grounds on which the notices of re-entry are challenged. The witness deposed that the said notices are void and are unenforceable now, that the letters of the government giving permission for additional construction were on record. Union of India was stopped from going back on the said permissions. Even in the letter dated 1st August 1986, the Union of India stated that it would institute proceedings to enforce the terms of the lease, including the right of re-entry, but wide notice. It has exercised the right of re-entry without recourse to any civil proceedings. This was contrary to the representation made by the L and do in its own letters. According to the witness, in other plots of the press enclave, subletting has been permitted, and examples of the same have been set out in the affidavit. The impugned notices terminating lease are in contempt of the specific directions of the Supreme Court, that the only pending issue was the payment of conversion charges only. Even in the past, subletting has taken place prior to the execution of supplemental lease deed